Hello, everybody. Welcome to myHRcounsel's third Tuesday webinar. This month, we are going to be presenting Parting Doesn't Have to Be Such Sweet Sorrow, Conducting Smoother Terminations. I am trying something different this month. I'm not calling in to the meeting. I'm actually using my computer audio. If somebody wouldn't mind letting me know in the questions box if everything sounds okay. I'm hoping it does. If it doesn't, I'll call into the meeting. But if there's any issues with the audio, please let me know. Sounds good. Okay, thank you. Already got somebody saying it sounds good. So if there's issues, let me know. Otherwise, I'm going to go forward with using my computer audio. All right, so my name is Janelle Stanton, do the third Tuesday presentations just about every month. For those of you that were able to join us last month, we were fortunate to have our partners at Lurie, who are actual tax professionals and accountants, help us out with the presentation. So hopefully you guys were able to attend that presentation and got a lot out of it. We are always looking for other ways to loop in experts for you guys. So if there are other topics or other individuals that you would like to hear from or something that might be helpful, please let us know, because we really take that seriously, and we got some really great feedback about our webinar last month. So happy for all of you that were able to attend. And again, if anybody is interested in getting a recording of that presentation, it was, we did present with a group of tax professionals on financial benefits that are available to companies due to the COVID-19 pandemic. So if you missed out on it or would like a recording, let me know. If there's other types of presentations like that you guys would appreciate, let me know that as well. So this month we are going to talk about terminations, and this isn't, of course, anybody's favorite topic, but it is something that we all as HR folks find ourselves in the position of having to do every once in a while. I have not been immune to this. I've also had to conduct terminations in my role as well, and certainly it's not fun, but I do think there are some really concrete ways that if the proper steps are taken, we can kind of take some of the heartburn, not all of it, but some of it, out of having to conduct a termination. So with that, our agenda today, and I do anticipate probably running a little on the shorter side this month, so maybe some of you will appreciate that. I know I've said it before, I rarely end up presenting a short presentation, but it could happen this month. We'll see. So we're going to talk about the limits of at-will employment and sort of what it is and how it is limited. I'm going to talk about conducting risk assessments and looking over your documentation. Then I'll talk about actually conducting the termination meeting and how to deal with the aftermath. As always, we are recording this presentation, so you guys will all get a copy of the recording if it's something you want to look at again, or share with somebody else in your office. That's perfectly fine with us, but we will make sure we get that shared with you. You're also going to get a copy of the slide deck, so we'll send that out after the fact as well. There are some really, I think, helpful slides within this presentation, especially the conducting risk assessments slide is kind of something that could be used as maybe a bullet point checklist. But I am also going to be sending out a best practices checklist to everybody as well. So it'll have a whole lot of information, but it's a checklist that would, essentially lay out all of the best practices for conducting terminations. We did receive 1 hour of HRCI recertification credit. So everybody that is in attendance that needs those HRCI recertification credits, you'll get the code sent to you in email. I want to point out, because I've had a few people ask me about this before, so the HRCI credit code is only available to people that do participate in the full webinar. So unfortunately, for those that might be in your office that are watching it on replay, the code is not available to those individuals, and we ask that you not share that. HRCI really wants to make sure that people who are credentialed are receiving the credit for being in live attendance. So sorry about that, but HRCI is kind of a stickler on those things, so we would appreciate if you would honor that as well. And then again, we always will be sending out that survey. You know, we don't get a ton of responses, and I know I'm really guilty of this myself. I find myself a lot of times without a ton of time to be able to do surveys, but if there's something you've been dying for me to present on, let me know, and I will make it so. I like presenting things that people are interested in. This is the reason for the presentation today. Somebody did give us some feedback that they'd like to talk about this particular topic. So happy to oblige, just let me know. All right, so let's dig into the content here. So a lot of times what I hear from a client is, this is an at-will employee. I can fire them for any reason that I want to. And while at-will employment can seem like a very useful tool for employers, and it certainly is, there are some very serious limitations to the at-will employment doctrine. And just as a reminder, an at-will employment situation is one where employers are free to terminate an employee for any reason and without giving a reason in most states, unless it's an illegal reason for the termination. So you can terminate for any reason except for an illegal one. And employees can also, they can voluntarily resign, they can leave employment at any time for any reason and are not required to give notice. So again, at-will employment, you can be terminated for any reason except an illegal one, and you can also leave employment at any time without any notice, and you can't be penalized for that. So the sticky wicket here with at-will employment is you can terminate an employee for any reason except for an illegal one. Well, there are a lot of laws that protect employees from illegal terminations. And that's what makes this so complicated, is all of the different laws that are in place. And a few of those here that I will mention. First of all is Title VII of the Civil Rights Act. That Title VII prohibits discrimination on the basis of race, color, sex, national origin, and religion. So you cannot terminate an employee because of their race, color, sex, national origin, or religion. So big, huge, sweeping law there that protects employees. Another one here that protects employees, of course, is the ADA. So under the ADA, employers are not able to terminate employees or discriminate against them on the basis of a disability. So employees that have a disability or are regarded as having a disability are protected and cannot be terminated on that basis. There's the ADEA, and sorry about the alphabet soup here, but that's just the nature of employment law. The Age Discrimination in Employment Act. That law prohibits discrimination on the basis of age, 40 and over. Note, though, that there are some states that lower that age, or that say that employees of any age are protected from discrimination on the basis of age. There's also the Genetic Information Non-Discrimination Act, or GINA, that prohibits discrimination and termination on the basis of an employee's genetic information. There's also USERRA, the Uniformed Services Employment and Re-Employment Rights Act, that prohibits discrimination on the basis of past, current, or prospective military service. Okay, I have a note that my audio is fading in and out. So if I see a couple of other people comment about the audio here, I may pause and call in, but hopefully not the case. So let me know if there's other issues with my audio here. Sorry about that. And then there's also other laws involved. So you have to remember that these are all federal laws that protect employees, but then there are also state laws. So where Title VII considers as protected classes, race, religion, national origin, color, and sex, other states have additional protected classes. For example, the state of Minnesota protects individuals with both a mental and physical disability. The state of Florida protects individuals who have sickle cell traits. So you have to be aware of all of the different protected classes in all of the different states that are involved, because those do change depending on state and local law. Sounding good in Ohio. Awesome. Thank you so much. All right. Sorry about the audio, but do let me know if there's any issues. So thank you for bringing that to my attention. Another area that employers have to look out for when considering at-will employment is there are many leave laws that also protect employees who either request or take advantage of the leave that's provided to them. So one of the biggest ones, for example, is the Family and Medical Leave Act. And many of you are very aware of that law. I'm not going to go into a lot of the specifics there, but covered employees who take up to the 12 weeks of leave, they are usually protected in all but some very rare circumstances and should be given their jobs back after they return from FMLA. Like I said, absent some unusual circumstances, individuals who take FMLA leave are entitled to be restored to the role that they had when they went out on leave, and failing to restore them or disciplining an employee for using FMLA, including potentially terminating them, can lead to FMLA interference claims. So something we definitely want to make sure that we're avoiding. USERRA pops up here again. And USERRA is what is the law that protects individuals who take leave for military purposes. For example, an employee who needs to go out for deployment if they're a member of the National Guard or another branch of the military, and they're set to take military leave. In most instances, again, those employees are entitled to be restored to their position, and terminating an employee for using military leave under USERRA would ultimately lead to violations of that particular law. Employees who take workers' compensation leave are also protected and entitled to be restored to their roles. There's a lot more that I could dig into on workers' compensation and the duty to restore an employee, but suffice it to say that those individuals who take workers' compensation, especially who take leave, they should not be terminated from employment unless there are, other circumstances that would warrant a termination. And then there's also the possibility that employees may take unpaid but job protective leave under the Americans with Disabilities Leave Act. And this is one that I will say is big and that a lot of employers kind of forget about, is the ADA and the fact that providing unpaid leave may be considered a reasonable accommodation in many circumstances. So if you have an employee that suffers from a disability and one of the types of accommodations that their physician recommends is a period maybe of 3 weeks of leave for an employee to attend some kind of intensive inpatient treatment for depression or alcoholism or something like that, the ADA can step in and say, hey, this particular employee needs to be given unpaid leave. It's a reasonable accommodation. And so in those situations, again, leave provided under that law is job protected, meaning the employee cannot be disciplined or terminated for taking leave under the ADA, and they also have to be restored to their position. And there's other types of leave, again, in particular states that might, provide pregnancy leave or other types of leave where the job is protected and that's part of what the law states in those particular states. So keep in mind that there are many leave laws that protect employees. Couple of other things. So whistleblower activities are protected. So terminating an employee who engages in a type of whistleblower activity is protected, and it would violate, it would be an illegal reason, and therefore at-will employment would not be a legitimate defense to that termination. So a couple of things here, Sarbanes-Oxley and Dodd-Frank. Those were Wall Street reforms and various types of consumer protection acts that stemmed from the 2008 banking crisis. But essentially, they protect and prohibit termination when an employee reports corporate wrongdoing. There's also the Occupational Safety and Health Act, or the OSH Act here, that prohibits termination for an employee who exercises their rights protected by federal health and safety law. So if an employee, for example, notices safety violations on the job site, maybe they've reported it to their supervisor without sufficient or without resolution, and so they go to OSHA or they go to some other agency and they report the company for those safety violations. Those particular employees would be protected by these various whistleblower laws. Another thing that employers should be looking out for is when employees engage in other types of protected activities. So one of the biggest ones here is protected activities relating to the National Labor Relations Act. So if your employees are talking about potentially unionizing, employers are prohibited from terminating employees for engaging in union activity. There's also what's called Section 7 rights under the National Labor Relations Act, and that protects employees from doing what's called concerted protected activity. And that type of activity would be, for example, employees getting together to discuss wages. Employees cannot be terminated for discussing wages and benefits of their job with other coworkers or other conditions of their employment. That is protected activity under the NLRA. So just knowing that, because I will say, I am very well aware that in many types of businesses and in many industries, not discussing wages and encouraging employees not to discuss wages is seen as something that's just appropriate and the right thing to do. However, it is a violation of the NLRA to prohibit employees from discussing their wages. So check out those employee handbooks. If you've got a prohibition in your handbook that says employees cannot discuss their wages and cannot disclose their salaries, make sure you take that out because that would violate the NLRA. And again, employees should not be terminated for that. A few years ago now, Jimmy John's, the sandwich shop, they got themselves in some hot water because employees were getting together to discuss their low wages and the fact that there was no paid sick leave and that employees were encouraged to go to work while sick, even though they were handling food for customers. they got together, they were complaining about those conditions, and Jimmy John's took the action that they shouldn't have taken, and they terminated several employees. Well, these employees raised cause of stink, and of course, they were in the news for violating these Section 7 NLRA rights. So don't be like Jimmy John's. Make sure you're not prohibiting employees from having those discussions. The last one here is under the FLSA, the Fair Labor Standards Act. So employees who seek to enforce wage rights, they are prohibited from being terminated for exercising those rights. So if an employee goes to a state agency, the Department of Labor, or other agency to say that the company is not paying appropriate minimum wage, they're not paying overtime, those activities are protected, and employees should not be terminated for engaging in those activities. So this is a slide that I was talking about that might be helpful to refer to in the future. So I just talked about all those laws, and it's, obviously difficult to sort of keep in mind, oh, FLSA and FMLA and ADA and ADEA, and what you can do is kind of use sort of a checklist in your practice in conducting those risk assessments, because realistically, anytime we want to terminate somebody, you need to think about, are there risks that I'm not thinking about? And definitely do this before pulling the trigger on a termination to make sure that you don't have to face an agency charge or get a letter from an attorney down the road saying you had done something illegal. So if the employee you're about to terminate has recently done any of the following, consider a yield sign. This is not stop sign area, but it's yield, because you need to think about if an employee recently filed a complaint of harassment, discrimination, or other unlawful workplace conduct. If you now terminate that employee, it can very much look like retaliation. So if you have an employee that filed a complaint, make sure you look into and dig into that more. Probably going to want to consult with counsel to see if there's a safe way to terminate that individual. For example, maybe somebody filed a bad faith claim of harassment or discrimination, and it turned out that the investigation was conducted and ultimately that complaint was made in bad faith. Can we now terminate that employee? Potentially yes, but it is worth digging into more. Has an employee participated in an investigation? So maybe they weren't the source of the complaint, they weren't the victim, but maybe they participated in the investigation and gave some statements. Look at that further. Did they report your company for any safety violation? Like I said, obviously employees are entitled to whistleblow. It's not fun. And, it can get your company in a lot of trouble, but it is a protected activity. And just note that there are, this is a really growing area of concern for a lot of employers as it relates to COVID-19. Employees who work for companies that are not, that were not participating in all the COVID-19 protocol as far as masks and distancing and sanitizing surfaces, things like that. Employees were going forward and reporting employers for those violations. They are protected in that activity. Employees who engage in union activities are protected, absent some pretty unique and egregious situations. And look at whether your employee has taken any type of job protected leave. So just kind of think about these 5 things. If your employee has recently done any of these things, think yield sign, look more into it, and make sure that you're absolutely safe before you pull the trigger and terminate that employee. And then think about, is your employee a member of a protected class? So just, in case you don't already know this, pretty much everybody's a member of a protected class, but are they a member of a protected class? Identify that, ensure that there's no way that this employee could take their membership in a protected class as the reason for their termination. Now, that's not to say that, of course, you can always terminate individuals who are in a protected class status because, again, everybody is. But is there any way for that the termination to be construed as on the basis of that protected class status? That's what we're wanting to protect. Is your employee suffering from a disability or other serious illness? Are they a member of the military? Are they pregnant? Think about that employee. Think about what is going on with them. Is there anything about that particular employee that should give you pause in conducting this termination? So again, these are kind of the recommended things to look into in doing that risk assessment before you terminate. And something I do want to bring up here, and I'm going to talk more about voluntary termination or resignation a little bit down the road here, but I want to talk about the concept of constructive discharge. Constructive discharge is when an employee quits because they felt they had no other choice but to quit. And in those situations, it actually is the employer who is considered to have constructively discharged the employee. And this most commonly comes up if an employee is subjected to severe and pervasive sexual harassment, or in certain situations, if an employee participates in a workplace investigation, they are bullied, but those bullies face no consequences. It's basically where an employee is pushed to the brink. They see no other option but to quit. In those situations, that's really not a voluntary termination. That's where an individual quits, and it is considered to be a constructive discharge. It's a termination by the employer because the employee felt they had no other option. The reason that I bring this up is because let's say you've got an employee and they've made a complaint about sexual harassment, and I don't know, you're not really buying it, or you do the investigation, but hey, it's a really important client of our company. I can't take action against this particular individual. The harassment continues, the employee leaves, and you think, great, I can't possibly get sued here because the employee quit. They resign. How can they come back and sue me? Well, they can, and it's usually called constructive discharge. So just be aware that that is a concept, and it is an area of where employers get themselves into quite a bit of trouble in failing to recognize that even though the employee voluntarily left, it can still lead to lawsuits and litigation down the road. Sorry about that. I keep muting myself to cough or have a drink. I've got a cold. So another really big thing, in addition to conducting risk assessments, that will help ensure that your terminations are smooth and friction-free and hopefully keep you out of the doghouse with litigation, are consistent application of company policies. And the reason that this is so important is because ensuring that you have policies and procedures in place that explain why an employee can be terminated are really critical. If you terminate an employee and you don't have a policy in place that you can go back to, that's when an employee can point to, hey, they didn't have a policy against my action. They actually terminated me because of I'm pregnant, or because of my protected class status, or any of those other illegal reasons that I just pointed out. So having a neutral, something that's consistently applied against all employees, again, is going to go a very long way to ensuring that if an employee is terminated, you can justify that there was a legal, business-related reason for that termination. couple of things that I, just will point out here. For example, having a good IT resources and communication system and social media policy, that can help employers defend termination decisions based on inappropriate use of technology. So if an employee is using, your email or their social media account to harass other employees, for example, you can point to that valid, that neutral policy as the justification for terminating that employee. I also always recommend a standards of conduct policy that helps employers defend termination decisions that are related to inappropriate personal conduct. So those types of policies typically say things like you cannot gamble in the workplace. You cannot, show you need to have good attendance. You can't, verbally accost your coworkers. It's just a standard of conduct policy. It delineates a number of actions or activities that your employee could engage in that would cause them to get fired, essentially. And also making sure you have an anti-harassment policy. So if an employee is engaging in harassing behaviors, again, you can point to that policy as the legal business-related reason for terminating that employee. But again, the really critical component here is applying those policies consistently. If an employer imposes severe discipline on one employee for a specific infraction, but little or no discipline on another employee for the same infraction, that's going to increase the risk of litigation because it can look like disparate impact. Like you are meting out too much discipline on an individual, usually because of their protected class status, and letting others off scot-free. And that's going to cause a discrimination issue because, again, that disparate impact, usually it's going to be on the basis of some protected class status. So making sure that you are consistently applying those policies. If you get a little loose on one policy with one, make sure you're doing the same for all. And that's why that equal and consistent application is really, really critical. But another component that I want to bring up here is getting signed acknowledgements of your policies. It's not enough to just give an anti-harassment policy or give an employee an IT policy. You have to get signed, or whether it's in hard copy or electric signing, either are perfectly fine. But you've got to have them signed off on because this is so critical to ensure that your employees have read them, have understood them, so that if an employee violates them, you as the employer can go back and say, no, we have this written policy, you read it, you signed off on it, you said you understood it, you violated it, and now you're being terminated because of that. It makes the termination defensible and much cleaner. It's when there's no signed acknowledgement that gets a little more difficult. Now, it's not impossible to defend a claim of discrimination or harassment or wrongful termination without signed employee handbooks. It just makes it's another piece of the puzzle that makes that defense much easier. So another thing I want to point out here is reviewing documentation before making the decision to terminate. I really can't underscore the importance of this enough. There are so many times that I have clients come to me and say things like, hey, we want to terminate Joe, but here's the thing. I don't have any documentation because all of the discussions we had with Joe were verbal and it wasn't written down. I don't have any write-ups, anything formal. I just have verbal conversations. and now we want to let him go. And so what happens if all you've had is these conversations that are not memorialized or written down anywhere, and then you terminate Joe? You don't have documentation to show the EEOC, a state agency, an attorney, or a court the actual legitimate underlying reason for terminating him. All you're going to have is word of mouth. And that memories fade fast. It's just an imperfect way to document those types of employee issues. And I really encourage my clients to document everything. You know, the smallest infractions should still be documented, because ultimately those small infractions can add up and they can become an issue. And we're not going to remember necessarily the 3 times that Jane was absent or late 2 months ago, because now we're just thinking about, now in hindsight, oh wow, she misses a lot of work and we want to let her go. So just writing down all of those little, you know, transgressions is really critical. And it doesn't have to be anything fancy. You can just open a Word document for each employee that you have and just record it. You know, Jane was late today. Jane called off you know, today and said she wasn't coming in, but didn't give a reason. Just write all of them down so that then when you're starting to piece things together, you know that you've got the right documentation. And like I said, contemporaneous documentation is important because memories fade. You know, I know that this is you know, something that a lot of couples face. Is, you know, you start thinking, well, you do this all the time. No, I don't do this all the time. I did it once, you know, and you don't want to have that situation with an employee. You want it documented, and you want it documented carefully. And I would say that if you were thinking about terminating an employee and the documentation is sparse, maybe reconsider the timing of that termination. You know, do a written warning, put them on a performance improvement plan, do something to get some stuff in writing before you take the step of terminating. Now, that's not always the case. And again, all I say here is reconsider the timing. There are some situations where just you can terminate the employee. You don't need documentation to do so, depending on what happened. But in most instances, having documentation and looking at it before you make the decision to terminate is going to be very helpful. Another word on documentation here, avoid, you know, be objective, avoid personal comments, overstatements, speculating, assumptions. You guys all know that, you know, what happens when you assume, you know, little joke, but realistically avoiding those assumptions, emotionally charged language, and just keep the documentation simple. I say, you know, it's not the 5 W's, it's the 4 W's. Who, when, where, what. We want to leave out the why, because why is a judgment call, and that's usually not going to be helpful in your documentation. So keeping it very simple and clear, focused, that will make sure that, again, if you do decide to terminate an employee, and now lawyers are looking at the documentation you put in place, we don't, as lawyers, we don't have to get heartburn about the things that were written down by your HR department or your management team. So just keep the documentation very straightforward, very simple. Another thing too that I always want to point out, and you might be like thinking, why is this part of a termination presentation? Well, I will say that the best terminations are not a surprise. If you terminate an employee and they're kind of like, oh yeah, you know, I kind of thought I saw this coming, beautiful. You've done literally everything that you need to do, because that means they understood what their performance metrics were. They knew they weren't meeting their performance metrics. They knew they were skating on thin ice. they knew they still weren't able to improve their performance metrics. So the obvious next step was a termination. That is the absolute gold standard. That's not always going to be able to be the case, and that's fine. But I think often managers really just want to focus on the positive aspects of employee performance, and they shy away from honest, real criticism of that employee's performance. And that employee then is just going to think, hey, I'm doing a great job. Nobody likes to be critical. It's not fun to have to tell an employee when they're not meeting their metrics, but that reluctance only prevents that employee from improving, and it prevents an employer from defending against a termination claim when they cite employees' performance problems. This happens all the time where, oh, you're doing great, you're doing great, you're doing great. Hey, we want to fire this person because they're doing really bad. Well, again, if that's the case, now it's starting to look like there is some kind of nefarious reason for the termination. Hey, all you've ever told me is that my performance is great, and now I'm getting fired. That leads me to believe there's other things at work behind my termination. So, if you're the manager and you're in a position where you're giving, reviews or things like that, you've really got to be honest about any employee shortcomings. Recording genuine performance issues accurately and in a timely way is going to preserve that legal argument that it was performance rather than some unlawful motive that was the reason for the termination. So, a few things about delivering the termination message. This is, i.e., having the actual meeting with the employee. There's a lot of things that should be considered when talking about and thinking about having this termination meeting. A big one is to time the decision to allow for privacy. So if possible, make sure that the meeting can happen at a time where there's not going to be many interruptions, maybe before or after the normal workday. Have a private meeting location out of the view of other office mates, if at all possible. Nobody wants to be fired, and if you can reduce embarrassment and give that privacy, somebody you might be terminating may cry or be very upset. You don't know how people are going to react. So if you can keep things, consider the timing, keep the situation or keep the environment as private as possible, it's definitely helpful. Another thing that I can't stress enough is to prepare for and possibly even rehearse delivering your message. That way, if you have it rehearsed and you have like a written outline or a list of talking points, you can make sure that you fully explain all the important points, including the reason for termination. You don't want to get lost in your thoughts and start saying things you don't mean. Oh, you're such a great employee, we're so sorry to lose you, but you're fired because you're doing a terrible job. You don't want to go down that road. You want to keep it very simple, rip the band-aid off, but rehearsing and sort of preparing what you're going to say will really help with that. I always recommend having another witness. Don't do the meeting alone. That's important because if you've got, maybe HR, but then another member of management that's in on the meeting, if there's questions that arise after the meeting and the employee says, oh, hey, they told me I was terminated because of my religious beliefs, it will be their word against two. You have another witness, but also it can help with safety issues if there's, potential safety issues that need to be considered as well. And definitely do be direct. Don't make excuses or minimize the reason for the decision, but do avoid any personal attacks or derogatory generalizations. Make sure that they understand that employment has been terminated. I have worked with clients previously where HR waffled and hemmed and hawed, beat around the bush, whatever you want to say, so much that the employee left and had no idea they were actually terminated. That's a very bad termination meeting. And again, if the employee is thinking, hey, I'm great, I'm doing a good job, they feel really bad about this, why are they actually letting me go? That's a recipe for disaster. So you want to make sure that you're very direct, you're not waffling, be clear. Be prepared for a negative response though. People may cry, people may get very upset. Notify security, get advice from legal ahead of time, because the unfortunate reality that we live in is that workplace violence does happen, and you need to be prepared. You know your employee. Is this particular individual somebody who could potentially commit a violent act? Do you need to get law enforcement involved ahead of time to escort the individual off the premises? Think through any of those big safety issues. And then, if possible, have some of that final stuff ready. Now, most states do not require that you pay an employee right away after you terminate them. A lot of states you can just pay by the next payroll date. If you can have final pay and a check ready to give them in person at the meeting, that's great. I know that's not always the case, but if you can, or if you can have insurance or COBRA information at the ready, so that there's no questions about what happens with their insurance, what happens with other benefits, 401ks, things like that. And if you can, you can talk about references that you might give, and being sensitive, and termination is difficult for anybody. I think even in situations where they're a terrible employee and you've got to terminate, it still is hard. So be fair, be professional in what you're communicating, have some empathy and be sensitive. Just be clear. There's a fine line there. So a couple of points about the aftermath of a termination. So, a couple of things you need to do. You need to collect employer property as soon as possible. So if you've given this employee a laptop, a cell phone, an employee and a company vehicle, make sure you get that property back as soon as possible. If you have issues collecting property, so an employee has to return a laptop or a badge and they're not doing so, understand the laws of the states where you have employees working. In most states, you're not going to just be able to deduct the cost of that property that's not returned from the final paycheck. So you can't just say, well, that laptop's valued at $500, I'll just take it out of their final check. Most states are not going to allow that, and most are going to require that you have the employee agree to have those amounts withheld from their check. If you're in one of those states, the employee doesn't agree to have the cost deducted from their final paycheck, most of the time your only recourse is going to be a lawsuit, potentially in small claims. So that's why I say if you can get company property back as soon as possible, it's going to by far and away be the easiest solution. Make sure you disable email, VPN access, especially if an employee is a security threat. Make sure that you have revoked any building access or or parking passes, things like that need to be disabled. And then consider enforcing non-compete, non-solicitations when necessary. Not all employees should be held to account for the non-competes or non-solicits that they've signed. Most of the time, your employee can leave, they can compete, and it won't impact your business. But that's not always the case. So if you have an employee that you've absolutely got to enforce a non-compete, non-solicitation against, make sure you remind them of their ongoing obligations under those documents as soon as possible. So whether that happens in the termination meeting or if it happens, you know, in a letter that you send off after they've left, consider that as well. I do want to talk about separation and release of claims agreements quickly here. So all too often, here's what I see. I see a very well-intentioned employer terminating an employee and then giving them, you know, a few $1,000s to sort of say, thank you, I'm sorry, goodbye. Well, if you're going to do that, if you're going to offer a severance, make sure that you get a signed separation and release of claims in return. Because here's what you don't want to have happen. You don't want to say, out of the goodness of our hearts, we feel so bad, we're going to terminate you, here's $5,000 to make the pain go away. They say, thanks for the $5,000, and then, you know, 2 months later, you have an EEOC charge letter, or you've got an attorney writing you saying, hey, you violated the ADA, and now you owe us $75,000. And you're saying, hey, I gave you $5,000 when you left, that should be good enough. Well, if you didn't get a signed separation and release of claims agreement, unfortunately, it's not. Because that agreement, essentially, it asks employees to waive lawsuit rights in exchange for getting either severance money or some other benefit like COBRA or job retraining benefits or things like that. So make sure if you're going to give a severance, get that separation and release of claims agreement in writing, get it signed before you pay the severance, please. And then, of course, not all the time, and hopefully most of the time you don't have to be the one involuntarily terminating your employees. There can be obviously situations where an employee decides that they're going to leave, they're going to resign, and that's fine. But there's still a few things that I would recommend keeping in mind about voluntary terminations. I already talked about the constructive discharge issue, so I'm not going to focus on that here. But if you have an employee that's resigning, get the resignation in writing. This prevents a situation where later on down the road, the employee tries to come back and say, hey, I was terminated because of my age, or because I was a whistleblower, or I was retaliated against for participating in this investigation. And then you'll be able to say, no, look at this letter. They resigned. There was no issues in place. Look, they quit. This is, again, separate from constructive discharge. This is just the usual situation when an employee leaves. Get that resignation in writing and have them set a date for departure. Because nothing is worse than sort of, I'm going to be leaving, and then having this open-ended sort of end of the employment relationship where maybe they've been working for a few more weeks and I don't really know when they're leaving and I don't know when the final pay is owed. Just set the date, plan for replacement, and move on. I really can't stress that enough. And just so you know, if an employee says, hey, I'm giving my notice, I'm going to leave in 4 weeks. If after a week, this employee is, not working, they've become a headache, it's a morale issue, etc., you can just terminate them. You can say, okay, well, nope, not 4 weeks, 1 week, you gotta be done Friday, sorry. You can do that. You don't have to wait out an employee's notice period. And then again, consider a reminder about any restrictive covenants before they leave. So if they're going to be subject to a non-compete or a non-solicitation clause, consider reminding them about that before they leave, because you can obviously still enforce those agreements against an employee, even if they resign that employment. So that's all I have as far as the material. I love to answer questions. I don't have any right now, but we actually, it's unheard of for me. I like to talk, as you guys are all probably very well aware. We have time for questions. So do you guys have any questions for me? Is there anything about what I've gone through that, piqued your interest? I Can't give you legal advice about a specific termination, but I can answer questions. And you know, I do have some time, and I'll wait while you guys kind of formulate your burning questions for me, but I really can't stress enough the safety issue. You've really got to think that through. I've had several clients in the recent past here have some safety concerns regarding an employee that they were terminating. Take those seriously. OSHA puts a duty on employers to protect and keep safe their other employees. So you've got to make sure that you are taking that seriously, and any credible threats, again, contact law enforcement, call in security, don't meet with that individual alone, have a plan to walk them off the premises, give back their access badges, things like that. You've got to keep your employees safe, and just with today's climate, there's just way too much of these, you know, particular individuals who are terminated and disgruntled, taking things into their own hands and taking lives of other employees. So I know I don't like ending on that kind of note, but it is really critically important. So burning questions, any burning questions? Okay, here's one. Are there any states where at-will employment is not the law? Okay, that's a good question. So yes, Montana. In Montana, they've modified the at-will employment doctrine. So in Montana, if you are lucky enough to live in that beautiful state, just note that the at-will employment doctrine is different there. So Montana. All right, I got a couple more rolling in here. How do you handle someone who is out for COVID? They provided a negative test result, but failed to respond to any further email or phone call. So I'll call this ghosting. Say you've got an employee who has ghosted you. In that situation, if they're not responding to email or phone call, you can't get a hold of them, they're gone. What I would recommend doing is terminating them via written letter or email and just saying, hey, you've not responded to these 3 phone calls and these 3 emails. At this point, as of June 15th, 2021, your employment is terminated. Give them all the other information as far as final pay, COBRA, etc., and then let it go. If they call you back and they say, hey, I was actually in the hospital in a coma, you know, well, let's reconsider. But if they just ghosted you, put it in writing and just terminate them that way. Oh, got another couple here coming in. Oh, here, your example of telling an employee to be done working after 1 week rather than 4, does that change the voluntary resignation to involuntary? Yes, it absolutely does. So it would now become a termination, you know, an involuntary termination as opposed to a voluntary termination. There might be situations where you don't want to do that, where you don't want to involuntarily terminate an employee and that doesn't make sense and you'd rather keep it voluntary. So then, you know, you can, instead of terminating, you could talk to that employee and say, look, we really don't need a 4-week notice period. Can you be done after 2? If, you know, they're like, no, I want to do the 4, let it happen. Unless, like I said, if your employee is starting to not do work, they're not showing up, they're becoming a problem, then again, you might want to terminate them in those situations. Oh, here we go. This is a great question. If someone gives 2 weeks notice, but you let them go after 1 week, do you need to pay out the 2nd week? You do not. So the notice period, it's really just, employees are not required to give any notice. Any employee, because of at-will employment, can quit at any time. I can go to my boss today at 2 o'clock and I can say, I quit, bye. Right now. I mean, but it's professional courtesy. So if someone gives a 2-week notice, you let them go after 1 week. No, you only pay them for the hours that they worked. you don't have to pay for that full notice period if you're going to be letting them go. Great question. All right, anybody else? Thank you guys for these. These are great questions. All right, I'm not seeing any more. I'll give it a little bit of time here. So watch for the email to you guys. It'll have the recording. It'll have the HRCI credit code. It'll have the checklist I talked about. All of the follow-up items that I've talked about today will be in that email. You'll get that email either today or tomorrow. Give it some time. But thank you so much for attending our webinar again. We really do appreciate you guys. And I think, you know, again, let us know if there's anything that you guys want us to present on. Oh, here we go. Got another question. If you have a policy that states that an employee who misses a certain number of shifts without notice, they are considered to have voluntarily resigned, is that enforceable? For the most part, yes. If you say, you know, 3 no-call, no-shows is considered, you're considered to have voluntarily resigned, yes, that is enforceable in most situations. But again, in the, you know, unlikely event that an employee reaches out to you and says, hey, I was in a car accident, I was in a coma, then walk that termination or that voluntary resignation back, please. But in most instances, that's going to be just fine. So, all right, well, thank you for the questions. Look for that email, and always let us know if you have any questions or concerns. You can always reach out to us at info@myHRcounsel.com. Have a great day, everybody.